This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
What is that? Read out.
The issue of maintainability of the writ petition would be considered along with the aforesaid challenge on merits.
Yes. Aforesaid challenge on merit. Therefore, what I am hearing now, only your maintainability of the writ petitions and the challenge to the notice dated 19th May 2022 so far as it relates to creation of supernumerary posts for the work education and physical education. There is no ambiguity in the understanding.
There cannot be an ambiguity unless.
No,
you create it.
Mr. Bhattacharya,
Wait, my lord-
there may be.
My lord had asked me to remain confined on the question of
Yes, very well.
legality of supernumerary posts. I am also confining to that aspect. But while confining, but there are certain runover also. Therefore,
Yes, yes, maybe. Transgressing the areas.
আমি আমার অঙ্ক লাগবে তুই ঘুরে আসতে পারিস হ্যাঁ কফি টফি খেয়ে আসতে পারি কলা মধ্যে পাঠিয়ে দিস No, but therefore, I'm not. I just skip over since my lord is very particularly on insisting. But now, then kindly turn to paragraph 9, which deals with the supernumerary.
But I'll come back.
No, wait, Mr. Bhatta, please be here. Otherwise, what he is arguing, if you say,
Yes, sir. Mr. Bhattacharya will take some time.
no, maybe, but it is up to you.
Now, kindly state your will jump to paragraph 9. Skip over first 3 lines of the said paragraph. Then, with regard to the government order dated 19 September 2022, whereby the government proposed to create supernumerary posts. Kindly underline this: government proposed. And the cabinet memo says, well, the School Service Commission proposed. These are very interesting feature. And whereby the government proposed to create supernumerary posts for assistant teachers. I say that the state government order came as a policy of the government for accommodating waitlisted candidates. That is also the government stand. The commission, merely being a recommending authority, has no role to play other than implementing the directions of the School Education Department, for which issued the notice dated 14th October 2022, which is merely a schedule for conducting and counseling of assistant teachers for work education, physical education. I deny that the notification referred to are in complete violation of Rule 12.4 of the Rules 2016. I say that Rule 12.4 deals with the primary, upper primary teachers,
It is
except
misquoting. This 12.4 is misquoting.
misquotation 12.4, 13.4.
13.9.
That I have placed also on the last occasion. Then that means I deny that there has been any violation of Rule 13.9 of the Rules 2016, as the panels and wait lists were published according to the said Rules 2016. But this is a very important submission on behalf of the School Service Commission. Therefore, this wait list, my lord, is related to 2016 selection, where ratio 1:4 was maintained. With regard to the petitioners being called for verification after creation of supernumerary post and creation, I say the question did not arise that the supernumerary posts were created for leftover wait list candidates who are actually successful candidates who could not be recommended for want of vacancies. And my rule, my lord, prescribe the detailed method of, my lord, declaration of vacancies at the time of advertisement, and final vacancy 15 days prior to final publication.
Yes, that Rule 8 possibly is.
Rule 12.
kindly explain this situation, this 1:1. Supposing
I just give a Shiva. Now, my lord, I have vacancy, suppose X.
no, first of all, this supernumerary post would be, treated as vacancy.
Of course. So. But they admit that these wait list candidates, they could not be accommodated because there is no vacancies. Vacancies were notified as per the rules. And my lord, as per the notified vacancy, my lord, they have invited for further interview, for a further schooling or merit assessment, 1:1 ratio. If there are not 100 vacancies, they have to invite 140 people. By that process, the list is prepared, and according to the merit position, the top meritorious persons who goes to vacancies filled up. The rest persons who are called for interview are placed in the waiting list. Why waiting list? Suppose a person who was found to be in the merit panel within the 100 declines to join. Then, during the validity of the panel, person at the waiting list is offered.
No, whether this can be treated as vacancy.
Of course.
If it is treated as vacancy, then 13
9 has to be first.
has to be first.
That they say, the consistent pillar stand of the
And
authority.
in that event, the petitioners had a chance of
Everyone had the opportunity, to get a call.
how then by the cutoff mark will be lowered.
These are the now new vacancies, and the persons who are waiting may not be in the waiting list which has exhausted. They are also entitled to participate. When there are a vacancy, then you have to fill it up according to the procedure laid down under the law.
Mr. Bharja, make it clear. Now, waitlisted candidates, why the candidates have been put in a waiting list? Because there were not sufficient vacancies there.
And therefore, these vacancies become beyond the declared vacancies.
Beyond the declared vacancies.
If it is beyond the declared vacancies, then you cannot appoint from the said recruitment process. But
How your chance come then? If it is,
this vacancy now we have created X vacancies, it's open, who are entitled to apply as per the EGB, apply for these vacancies.
So this is a natural selection process.
Normal selection.
Normal selection process. But in a situation where if you treat this as vacancies, if you treat this as vacancies, how your chance?
I will treat this as new vacancy. They say these vacancies are created after the selection was complete, after the appointment procedure was complete. Therefore, these are vacancy creation. They say we have created this for the waitlisted candidates. Why waitlisted? Because they could not get chance in the declared vacancy.
Now, I want to understand one thing. How if it is treated as vacancy,
At least.
how the petitioner's chance comes
Yes, but if it is a vacancy, then what would be the duty of the government?
to declare it and then you take it in the new selection process. In this selection process, if these vacancies, this supernumerary posts are treated to be a vacancy,
Then what you have to do, you have to invite 1:1 ratio all the persons who are waiting. May not be the waiting list, but their standing might be below the so-called waiting list. But still, they would be.
but they must have the beyond the cutoff mark.
Yes, might be so.
1:1.
Now, cutoff mark changes as soon as you create the vacancies. The cutoff mark was created for the purpose of filling up the declared vacancies. That cutoff mark cannot come for the purpose of consideration of new vacancy.
So you say that as soon as it is a vacancy, your whole thing
has to do afresh.
Including the fixing up the cutoff mark.
Absolutely. Everything would be changed. You admit that we created this vacancy to quell the administration. I mean the agitation. That is the admission in the cabinet memo. Since the people were agitating, to stop the agitation, we have decided to create post for the agitating group. Can state do this?
At that point, আমাদের আর wait listed position same ছিল, can I explain?
And since Milord the and since the wait list conception is related, Milord, inextricably with the selection procedure of 2016, this wait list has nexus with the select list. If the select list is complete, wait list Milord vanishes. Apart from the question of Milord expiry, the purpose of wait list Milord is completely abolished as soon as Milord the vacancies are filled up.
So creation of supernumerary indicates that vacancies have been filled up. There is no vacancy has occurred due to non-joining or otherwise.
But if non-joining Milord, then the person who is at the wait list, he will be offered. And
But
this
Creation indicates that there is no such situation.
vacancies are complete, we cannot appoint you, don't agitate, we are creating vacancy for you. This is, Milord, fundamentally against the basic principles of Article 1416 and in violation of the recruitment rules. I shall take your lordship to law later. But I am trying to emphasize on the fact that this is the persistent stand of the state and the School Service Commission as well, that the vacancies were created for a particular section. It may be for a privileged section. I use this term. Then may I complete this note, paragraph 9. They were dealing with 13.9, 12.4 was a mistake. They have also may not say. They have, however, just down the middle. However, I deny that there has been any violation of Rule 13.9 of the Rules 2016 as the panels and wait lists were published in accordance with the Rules 2016. This is, in my humble submission, full stop. You admit that you have published it. Therefore, exercise of power under Rule 2016 is exhausted. Then they say, and in the ratio of 1:1:4, with regard to the petitioners being called for verification after the creation of supernumerary post, I say that the question did not arise as the supernumerary posts were created for the leftover waitlisted candidates who are actually successful candidates who could not be accommodated for want of vacancy. How could they be successful? We are also successful because we could not be accommodated in the vacancies. If there were vacancies were created, I create 20,000 vacancies. Everybody is successful. This statement of SSC is very interesting. On the other hand, petitioners, on the other hand, were unsuccessful candidates who were not even eligible for participating in the personality test. Because this personality test was vis-a-vis declared vacancy. If the vacancies initially was, which you have declared and subsequent vacancies, automatically you have been called for personality test. But this statement of School Service Commission,
So it cannot be says that you don't have any interest
well, I am most
in
vitally affected.
creation of the supernumerary.
This
post.
is absolutely, if I may use some, the argument doesn't hold any water. This paragraph 9 of the School Service Commission affidavit is very important and interesting. Then kindly come to me, Lord. In paragraph 10, they are dealing with Wemashis. I am not now troubling my Lord with that. No, actually.
You have to, you may have come back again.
I have to. I have to. Now, Lord, this is interesting. Kindly come to paragraph 14. I say, Lord, this is important. Lord, I had pleaded before your Lordship, which has been accepted by the division bench, upheld by the Supreme Court, that after the creation of this School Service Commission filed application before the court saying that we have created this post to accommodate illegal appointees. As soon as we took up the point, they wanted to withdraw. The Honorable Court refused. They preferred appeal. Appeal court giving a reason judgment refused. There's no, it cannot be withdrawn. Now they are dealing that. With regard to supplementary affidavit, I say that the said supplementary affidavit has been filed annexing 1 can application so-and-so, which has been filed in connection with WPA so-and-so, Shondip Prasad and others, which has no connection with the instant writ application, as the case of Shondip Prasad deals with the selection of Group D staff, which is a totally different selection process. Moreover, the purpose of creation of supernumerary as prayed for in the said can application is totally different from the purpose of creation of supernumerary post. That I have placed with that cabinet memo, this stand that is betrayed that. As proposed by the government order the 19th May. Hence, the question citing the can application while challenging the government order does not arise. It may be noted that the Commission has given specific written instruction to the advocates to withdraw the said can. But the facts are out. Now the cat is out of the bag. Now you cannot just say, I will put the cat again into the bag. Therefore, the both state and School Service Commission lot.
For a minute, a division bench judgment.
I paste that division bench judgment. এটা আমাকে এবার দিয়ে দেবে। But in this connection, I'll be placing that this is the division bench judgment. Lordship has seen so many writ petitions.
Show me 2 paragraphs from this judgment which deals with the locus standi point.
Yes.
Paragraph 70 or somewhere I have seen.
No, the honorable bench has dealt with that subject wise.
Paragraph 128 onwards. Recording sound.
I will kindly come to that page 159. Division bench.
Maintenance.
158, what's the maintainability?
Where I want to take.
We got paragraph 128 under the heading maintainability. Having understood the parameters of the matters, this is very important, which my lord also not thinking, what is the parameter within which locus has to be determined. Having understood the parameters of the matters, which we have to decide the issue of maintainability of the writ petitions needs to be answered. Persons opposing the writ petitions have questioned their maintainability. In order dated so-and-so, the Honorable Supreme Court enjoined maintainable writ petition have been questioned on the ground of delay, laches, and writ petitioners being at the behest of unsuccessful candidates who had participated in the selection process and failed. Various authorities have been cited at the bar on such an issue, which we shall consider presently. I am not detaining my lord with the authorities submitted by the respective parties. Then kindly turn to my lord, page 164. Lord, I am not really detaining my lord with the issue of laches, acquiescence.
147.
Now kindly come to analysis of the cited authorities on maintainability. 146. Authorities cited at the bar have underscored the underlying principle governing delay, laches, acquiescence to defeat a writ petition to be estoppel and prejudice. In the facts and circumstances of a given case, if the writ petitioner is found to be guilty of such delay and laches so as to have allowed third-party rights to intervene and attain finality, kind of underline this. third parties' rights have allowed third party rights to intervene and attain finality, then such a writ petition is not to be entertained. Similarly, when a writ petition is found to be acquiesced in a particular course of action, he is held to be estopped from questioning the same. However, these defenses of delay, laches, and acquiescence would not have application when the existence of fraud is established. No appointment can be made after the expiry of the panel. As the panel is not a perennial reservoir of appointments. Panel is valid for declared vacancy and for the specified period. Now, this will have apt application before your lordship also. Appointment towards future vacancies cannot be made from the panel. Appointment made in violation of Article 1416 of the Constitution of India are nullity. Courts have no jurisdiction to direct appointment to be made beyond the validity period of the panel. I don't think your lordship need to go further on this particular issue. The nature of the writ petition. Paragraph 150, I just giving the glimpses of facts in that issue. A candidate who had participated in the recruitment notification for third regional test 2016 for the post of clerk has filed so and so. He had avowed in his writ petition that the board had issued a provisional appointment letter in his favor for such post on March 2020. He has stated that such letter was issued 3 days before commencement of the COVID pandemic. He had gone to school at which he was given appointment but was not allowed to join. He had prayed for a writ to allow him to join in the post of clerk. Writ petitioners in so and so alleged that they participated in the selection process for Group D. They have claimed that the authorities had acted dehors the 2009 rules by not publishing the fourth phase counseling list and not calling the petitioners thereto. They have claimed that the authorities did not prepare and publish the panel in accordance with rules and that the entire panel was full of discrepancies. They have alleged that the entire selection process lacked transparency. They have claimed that several candidates holding rank below them had been given appointment. Similar allegations here. They have given details of some of the persons who were ranked below them but given appointments. They have sought appointment to the Group D post and cancellation of the notification declaring the panel to be expired. But other factors are there, many things. And all, after having considered all this, the court says this is a issue is no issue at all. Then kindly come to me, Lord. Paragraph 160, delay on the part of the petition and maintainability, because they might indicate this.
So 163 things.
163 on a on a purposive reading of the writ petitioners, one cannot arrive at the explicit finding that any of the writ petitions or the prayers made therein barred by law or do not disclose a cause of action. But I have been repeatedly arguing this before your lordship. The writ petitioners are entitled to approach the writ court with the prayers made on the basis of the pleadings as existing in the writ petitions. At the bare minimum, the writ petitioners allege misadventure by the authorities in the selection process. The writ petitioners are the participants of the selection process, albeit unsuccessfully by most, in respect of which they allege misadventure. They are entitled to a fair consideration in the selection process, a fundamental right under Article 14, denial of which they allege in the writ petitions.
166.
Then lordship may skip over. Kindly come to paragraph 166. The nature of misadventure alleged is such that such allegation cannot be dismissed at the threshold or as not disclosing a cause of action to approach a writ court, or such allegation being barred by law must not be inquired into by a writ court. Quite to the contrary, if the statements made in the writ petitions are taken as true and correct, then they make out a case of transgression of fundamental right to be treated fairly in a selection process undertaken by the state authority. whether the writ petitioners will ultimately receive any relief on the basis of the pleadings of the parties completed after affording the parties opportunity of filing affidavits, and the prayers made in such writ petitions would be a different issue. On the face of the pleadings contained in the writ petition and taking such pleadings to be true and correct, on the principle akin to consideration of an application under Order 7, Rule 11 of the Code, it cannot be said that any of the writ petitioners are barred by law or does not disclose a cause of action, and that any of them must be dismissed as not maintainable at the threshold. This was my argument in brief. Now, in this background,
Kindly take the pain of just mentioning the paragraph numbers.
Lord, I have
Mr. Dasgupta, have you taken
Yes.
a note of it? What are the paragraphs number?
128,
একজন বলো
146,
148,
147, 160, 160, 160.
যশোর লিখছে
Tell me.
জোরে বলো, জোরে।
146, 147, 160, 163, 164, 166,
167, 168.
yeah, 167 and 160.
Therefore, here, my lord was kind enough to confine also the creation of supernumerary post. Now, state, my lord, in his affidavit said we have administrative power. That is beyond constitution. Now, kindly, my lord, takes up the Constitution of India. Let us see, my lord, the executive power of the state. কি? কোথায় দাও তাহলে দেখিয়ে দিই। I missed it. This SSC, they filed with a supplementary affidavit.
So,
But this is of 19th February 2024. We kindly turn to paragraph 4. But if your lordship kindly permission, may I put on the hat?
yes. Yes.
এইটা জল টানতে হবে। But kindly come to paragraph 4.
এটা শুনি না ওই হলুদ ফাইলটা কোথায়?
Paragraph 4 of
এটা
19th February.
paragraph 4 of the supplementary evidence.
Yes, supplementary affidavit dated 19th of February 2024, affirmed by Mr. Amolesh Raut. Paragraph 4. It may be noted that by an order dated 19th of May 2022, which is challenged before your lordship, the government created supernumerary posts for assistant teachers for class 9, 10, 11, 12, and for non-teaching staffs, group D, C, to accommodate those waitlisted candidates who were adversely affected due to rank jumping, supersession by some other holding a lower rank. Same order also created a total number of 16 supernumerary posts for physical and work education for all waitlisted teachers for co-education physical education. After the creation of said supernumerary post and subsequent receipt of 1600 vacancies, we'll underline this. Subsequent receipt of 1600 vacancies from the school education department. Now kindly just recollect the rules. When the final vacancies are approved by the state, then we'll have advertisements. On 29 September, the Commission published a notification in its website for conducting the counseling of the remaining waitlisted candidates. Therefore, admittedly, my lord, when the counseling begins, it means, my lord, they take these vacancies, my lord, which are subsequently created as part of the original vacancies and not declared. In the division bench judgment, Lordship is pleased to note it that no appointment can be given beyond the declared vacancies and after expiry of panel. Which was held between 10th November and 16th November.
What is the meaning of remaining waitlisted?
Yes.
Remaining?
Some waitlisted, this is a huge scam. Some waitlisted blood who were ought to be waitlisted got already appointment. Even the investigation.
I can only derive a meaning from here. Of course,
they can explain.
Commission has to explain. Remaining possibly indicates that from the wait list, somebody has already been given appointment.
That's somebody who were entitled to get because of someone has refused. Out of 100, 5 might have refused. Therefore, go down 1, 2, 3, 4, 105, they were afforded the appointment. Therefore, the waitlisted function will not become completely exhausted. Therefore, they say remaining waitlisted. And then the counseling process comes.
The rule prescribes how the persons or the waitlisted candidates would be appointed.
Yes, rule says.
Rule prescribes the procedure.
Rule
Then
says categorically it has been placed.
1:1.4.
1:1.4.
To that ratio, there will be the calling for the counseling. From there, a main panel and a waiting list is prepared. Rule must have indicated or has prescribed
indicates
that how this waitlisted candidate will be given appointment.
That is prescribed in the rules. That as
Can you show me?
yes, kindly turn to the rules. Rule is at page 248. At page 250, rule 13 is the method of selection.
252.
252, yes. Rule 13. This is the method of selection. There, Millard, sub-rule 9 says
1:1.4.
Then, Millard, the final list is prepared. Kindly come to Millard, sub-rule 11 is very important. The Central Commission shall also prepare and publish in their website a panel of candidates category-wise equal to the number of vacancies and category-wise waiting list for the rest of the candidates from merit list who were not included in the panel. From the panel, the Central Commission shall prepare region-wise list of candidates on the basis of option exercised by the candidates and publish in their website, provided that the written answer script or OMR shall not be reviewed or re-evaluated. Provided then second proviso, also that the number of qualified candidates to be called for personality test shall not exceed, mandatory, 1.4 times the number of actual vacancies published at the time of declaration. The rule was so compact to prevent any sort of extra mechanism. Rules are prepared to ensure that no bad water rushes in. Then kindly come to what would be the situation when someone in the list does not join.
Vacancy declared at the time of result of written examination as per the clause B of sub-rule 3 of rule 8.
You cannot go beyond this. Statutory rules. State also cannot go beyond this. Now kindly turn to bullet 16. Validity of panel and waiting list. Both have validity. Each panel and waiting list.
This is admitted position. This is admitted position.
Admitted position, but fantastically they say it stands automatically extended. Affidavit says.
provisoটা
Then my lord,
16
16 first proviso, provided that names of candidates shall not be recommended against any post other than the post applied for or against any vacancy which has not been notified. Where do we get authority to create post for waitlisted? The waitlisting is prepared because of notified vacancies. And then you, in the affidavit, say, being a statutory authority, that they are qualified, others are non-qualified. If this is not, my lord, scam always doesn't mean, my lord, exchange of money. This is a scam when you deliberately violate the rules to accommodate XYZ. Then notwithstanding anything contained in sub-rule 1, a panel, waiting list, merit list prepared by each of the regional commission before coming into force, but that remains. Then 17, recommendation of candidates for appointment. My lord was asking me what is the mechanism. Well, may I place it, my lord? The regional commission shall hold counseling
You
with
are
a
on-
view
you are on rule.
17.
Yes, very well.
Now the regional commission shall hold counseling. Now that in the affidavit they say that we have started counseling for the waitlisted candidate, for which subsequently posts were created. Not had Shukumar been alive today, well, I don't know what would have written. Notwithstanding anything under sub-rule 1, a panel, waiting list and merit list prepared by each of the regional commission, I am not sorry, as 17. The regional commission shall hold counseling with a view to recommending the name of the candidate from the list for appointment against each vacancy. Thereafter, the regional commission shall recommend the name of only one candidate against each vacancy depending her position in the panel and availability of requisite vacancies, and a copy of the letter recommending the name shall be sent through speed post. A recommendation letter shall remain valid for a period of 90 days from the date of issue. Well, all these aspects were taken into consideration. Then kindly come to the sub-rule 5. If a candidate refuses to accept her allotment of post during counseling, or Central Commission gets information from any school or from the district inspector of schools or otherwise that a candidate recommended for appointment has not accepted the offer of appointment or joined the post within the stipulated period, or such a candidate refuses to accept appointment, or further scrutiny it appears that the candidate has misrepresented the facts. All these provisions are there. Then the Central Commission may do away with his name from the panel and will be deemed to have been depaneled and recommend the name of a candidate from the waiting list, strictly within the validity period of the panel and waiting list. It's a complete procedural letdown to prevent any hanky-panky. Now, here, Lord should carry notice, the commission has been empowered to, my lord, remove that person on a further squeeze. It appears that the candidate has misrepresented the facts. But here they say, oh, yes, there are mismatching. Now, because there are a mismatch, I create new posts. Law says if there are mismatches, remove them. and give it from waiting list. You want to keep those mismatching candidates well valid happily, and without following the rules.
There is no allegation against the waiting list candidates that there
Not
is.
the allegation against the entire selection process.
No, that is the other part.
No, therefore,
We
yeah,
are,
but this waiting list is this outcome of the selection process. Waiting list.
I wanted to know, it's when the selection process in 2016 has got two parts. What is the reason why this was not included in the main selection process of
But the
work education?
Milord, the
physical
vacancy selection procedure is well laid down. Lord, you have seen, Milord. I mean, this it again. Therefore, they say that the first declaration of vacancy at the time of advertisement, then further.
No, Mr. Bhattacharya, what I want to know, there is a 9, 10, 11, 12, Group C, Group D in one. And why these two has been...
These, incidentally, these petitions were not before the Honorable Court. Then.
Why these two separate...
This is the physical education and the work education is a different craft, different stream. In only confined to upper primary school. That's why this.
There was 9, 10, 11, 12, Group C, Group D.
Just interrupting. Today, in 2025, the rules are one rule. 9, 10, 11, 12 and upper primary, one comprehensive rule. In 2025. In 2016, the rules were different. Different means there were separate rules for upper
2016 rules, but,
yes,
but two
looking
different
at 2016 rules.
Two different rules.
Yes.
Three different.
Therefore,
three different rules.
That is
Thereafter,
implemented.
2016 rules, 2019 rules, then 2020.
No, 2016 there are two rules for
Yes.
9, 10, 11, 12.
9, 10, separate.
one rule. Milord,
Three rules. 9, 10 is separate, 11, 12
Group
is
C, Group D,
separate.
I am teaching.
9, 10 and 11, 12
upper
primary.
primary.
All three.
Three rules.
Now, therefore, Milord, now the issue is Milord specifically confined to supernumerary post. Now, Milord, I was pointing out, my Lord, Milord, the supplementary by Mr. Amalesh Chandra Raut.
Paragraph 6.
Milord, my ultimate argument would be, Milord, SSC, 19 February. That because of the they Joshua ke deya chota.
কোথায়? - 2024.
Now I was at paragraph 5. After the creation of said supernumerary post, might be like the risk of repetition. Therefore, the creation of supernumerary post is after the selection of the over. On 29th of September 2022, the Commission published a notification dated 14th October on its website for conducting the counseling. Now, when you see the conducting the counseling of the remaining waitlisted work education, physical education. Therefore, on that date, you accept that the waitlist candidate, the waitlist was alive. And when you say counseling, therefore, you are going back to 2016 rules. You know my source of power is the rules, not beyond that. A copy of the notification annexed. In terms of the said notification, the counseling was concluded and the recommendation letters are issued in favor of all the remaining waitlisted candidates. However, by an order dated so and so, board was restrained. Then kindly come to paragraph 7. It may be noted that at a much later stage, the Commission, in a totally different set of writ applications challenging selection process with regard to appointment of Group C, Group D, had filed applications for appropriate order the said applications were filed in the month of September 2022 for creating supernumerary posts to accommodate the candidates whose appointments were subsequently found to be invalid, so that there will be loss of job the said candidates would means a livelihood. However, the commission did not place the said application before the honorable to withdraw the said application, as I have already said before Lordship. Now, kindly come to paragraph 11. It is abundantly clear now how far the state authorities can create misgivings that the supernumerary posts created by state by order dated 19th May 2022 are different from the supernumerary posts mentioned in CAN application. The supernumerary posts created by the state had already come into existence and were made for accommodating waitlisted candidates who had found their positions in the waitlist as per their merit. The supernumerary posts mentioned in CAN filed by the Commission have not yet been created. Now that in the background of this, I am compelled to take your Lordship to the Cabinet memo to show how far these authorities, either they got themselves confused or they are trying to confuse the whole world. Yes.
Kindly clarify this paragraph 11.
Yes.
I'm a little bit confused.
No, I'm confused. In the kindly takes me the application which they are referring to, that is also annexed.
19 May 2022 are different from supernumerary posts mentioned in CAN application of the Commission.
Yes.
So, on 19th May 2022, then when the application was found or filed?
This application was found by them.
This one, the earlier before the.
Yes, that is part of annexure. But
September 20.
the CAN is a part of annexure. It was filed in September. It is September 2022. Specific date is not mentioned. 27 September.
Annexure R1 is the application.
Yes.
27th September 2022.
Now kindly come to paragraph 6 of the application. এখন আইনে ঢুকিনি।
So there, in addition to this, there are more supernumerary posts were created.
That is they want to say.
Such exercise means not to proceed with such exercise means
Not to proceed with the
creation of supernumerary posts.
no, such exercise means that they mean to say in paragraph 6 really follow. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified, is humbly proposed that apart from giving recommendation and appointment to the genuine candidate as observed by this honorable court by order dated 21st September, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid since the matter was pending. But they all knew ultimately all this will be declared invalid.
But the paragraph 11, what I could gather, that there is one set of supernumerary posts
That-
under notification dated 19th May
There is no other.
2022.
But that is their misunderstanding. They probably wanted to communicate that Group C, Group D 1911 is different from physical education.
But by one notification,
Yes,
such
kindly,
supernumerary-
kindly come to cabinet memo once again. I was saying this is very
Cabinet
important.
mode of the-
Supplementary affidavit.
Supplementary affidavit আছে cabinet memo আমাদের supplementary affidavit.
petitioner supplementary affidavit.
Affidavit dated 19th June 2025.
Now, is cabinet memo again I just refer to my lord. This is proposals and I got it. Proposals for creation of supernumerary post of assistant teachers including physical and work education. Therefore, this is the comprehensive cabinet memo. No separate. Then Lordship may skip over my lord, item 1 which relates to 9-10. Item 2 relates to 11-12. Item 3 rather item C. Group D, D Group C. Then kindly come to E. For the teaching post of physical education, work education, a total vacancies of 2,373. This is declared vacancy. Total numbers of candidates recommended was 2,194. The panel expired on 11 December 2019 and the decision is taken on 2022. They recognize this fact. Grievances on the said recruitment. A number of cases are pending before the Honorable Single Bench and Division Bench of the Honorable High Court, alleging that recommendations, appointments were given either in violation of merit or recommendation appointment given beyond panel and wait list. Same allegation. Allegation against all these appointments were same. In the meantime, one Shoma Das, the petitioner alleged that in spite of her merit in wait list, she was not recommended, whereas candidate not even in the wait list got recommendation and appointment. The Honorable Court requested the Principal Secretary to look into the matter of the petitioner so that if possible she can be engaged in future. The School Education Department also considered the proposal of Commissioner of School Education with regard to the demand of waitlisted candidates, physical and work education for appointment in their favor. Now here is interesting development. The Shomadas issue was also raised before the Honorable Supreme Court. The Honorable Supreme Court said Shomadas was an exceptional one. We upheld that, but rest we set aside. Which includes, my lord, the decision-making process of this memo is set aside. But the Honorable Supreme Court did not permit CBI investigation. That the cabinet memo, that was the view, the cabinet
Civil investigation to the extent of,
creation of supernumerary.
no, the observation is very, where is that second part order?
But
Of the Supreme Court?
In respect of the creation of supernumerary post. So that the order is 8th of April. I am reading out not loudly. We have Joshua copy আছে তো?
We have copies.
আচ্ছা,
তলায় দুটো Supreme Court.
আছে তো?
Next one, another is there, দেখি এটাও দিন আর
চার
একটা
পেজের থাকে।
মেন
ওটা মেন অর্ডার
Third April order.
no no
Third-
8 April order
8th April order. 8th April order is there.
এটা দিন এটা দিন
8th April order is also there.
In paragraph 52 of our judgment, dated 3rd of April, it was held that the issue with regard to the direction for investigation by the Central Bureau of Investigation vis-a-vis the decision to create supernumerary post would be dealt with separately. Therefore, this is the issue. And there the Supreme Court says, next page, my lord, the last but one paragraph, having regard to the aforesaid discussion, we are of the view that the High Court was not justified in referring the issue of creation of supernumerary post pursuant to the cabinet decision for investigation by CBI. This was the direction issue. And the court says that this, we set aside this part, but this will not in any way affect. We, however, clarify that our observations and directions given in the present order are limited to the extent of directions for investigation into creation of supernumerary post and do not in any way.
But Mr. Bharat, please see this, page 2.
Page two.
Perusal of the note dated May 5, 2022.
Yes,
Which note is referring to?
cabinet decision.
Which makes out a case of cabinet decision.
Yes.
Reflects that it was recorded that the power of section 19 and this one may be used in respect of waitlisted candidates, but the same shall be subject to outcome of the pending.
Litigation, yes.
Section 19,
Direction by which they say section 19 empowers the state give direction to the School Service Commission.
very good. This case was taken by the cabinet decision such and such. It may be relevant to take note that clause 2 of Article 74 and
Yes.
clause 3 of Article 163 of the Constitution of India, which specifically state that the question whether any, if so, what advice was tendered by the Council of Ministers to aid and advice of the President or tendered by the ministers. এটা ছিল না ওখানে? এটাও লিখে দিয়ে দাও, মাফ করে দিলাম। Yes, minister to aid the advice of the president or tendered by the ministers of the cabinet to govern shall not be inquired into any court. However, clarify that our observation and direction given in the present order are limited to the extent of the direction of into the
Yes.
creation of to that cabinet decision.
There was no criminality. Now kindly Tula takes up the Constitution.
ক্যাবিনেটটা পড়ছিলেন
Cabinet memo. Sorry, I was on the cabinet memo.
রাখো যেখানে ছিল।
Now, my lord, this is important because this goes against the affidavit by the School Service Commission. School Service Commission says that the supernumerary post was proposed by government, but the cabinet memo is otherwise. The third page proposal 2, item 2, proposal of Central School Service Commission and Commissioner of the School Education. But this runs contrary to the affidavit by the School Service Commission. The Central School Service Commission, the chairman of the Central School Service Commission, beat a letter dated 22nd April 2022, placed a report to the state government stating that 5,261 numbers of candidates have been affected by rank jumping. Admission of candidates have been affected by rank jumping in the first SLST 2016, third is RLST 2016, Group C and Group D staff. 1932 post of assistant teacher for class 9-10, 247 post assistant teacher for class 11-12, 1102 posts for Group C and 1980 posts for Group D. And if all the similarly placed candidates like Shoma Das are to be recommended, then 5,261 posts are required to be created. Again, new post.
It is the proposal of the commission. What is the difference between that application and this
No,
proposal?
the affidavit says this is the decision of the state. I just once again said.
This was the proposal of Central Commission.
Central Commission initiated the proposal. What I mean to say, the Central Commission, not having appreciated that there are illegalities galore, the agitations were going on, therefore we proposed this.
But then what is the difference between the stand of SSC
No,
disclosed in that
I want to
application?
Well, I want to submit to your lordship that all the authorities were really fighting against each other to shelter them. Because everybody knew this is illegal. But somehow or other I have to save my face. Therefore, all these things are coming. Now Shoma Das to be recommended like that. Now the Shoma Das Supreme Court has not got sanction, but not the others. But I would submit, Lord, that is my conclusion when I was concluding, that by virtue of the Supreme Court judgment, Lord, everything goes constitutionally. I'll come to that. Then the chairman, West Bengal School Service Commission, further, Videy's letter dated 25th April 2022 placed a report to the state government. Not I am skipping over the Group C, Group D because they will say different thing. The West Bengal Board of Secondary Education also confirmed the fact that such appointment of non-teaching staff beyond the list, as reported by the commission. The chairman of the commission further stated that for teaching post 9, 10, 11, 12 who do not feature in any list, either in panel or in wait list, should be cancelled by the commission without waiting for direction of the Honorable Court. Similarly, for cases relating to non-teaching staff Group D who do not feature in any list, panel, wait list, so and so should be cancelled. Then, Commissioner School Education, Videy's proposal dated 4th May 22 has proposed to create 1,600 numbers of supernumerary posts, break up 750 for work education and 850 for physical education, to absorb all waitlisted candidates of physical and work education subject to validation of panel. Where is the validation of panel? How could the School Service Commission
Debate at all.
How could the School Service Commission, without going based on recommendation, say we have recommended the names? Thereby alluring the unemployed youth to feel more agitated and agitate against the councils? These are the allurement. You yourself says that it is subject to validation of panel, and you know there was no validation of panel. But it requires, in my humble submission, very strict measure against these officials who are public servants paid out of the public exchequer. They are creating dissension. And dissension against the entire system. Now, department's views. But I'm straightway coming to the issue in question, 3 Roman 2. 1,600 supernumerary posts be created for absorbing all waitlisted candidates.
So the proposal was moved from the end of the commission.
And then they say absorbing. Whom do we absorb? Those who are not in employment, how can they be absorbed? That will be fresh recruitment. With absorption in the service jurisprudence has different meaning.
The person is still that who has the recommendation was made by.
But I don't know who was then the chairperson. Recommendation was made in 2022.
Still he is the chairperson.
Siddhartha Manoj.
এই অর্ডারের পরে রেকমেন্ডেশন হয়েছে মানে